Hello and welcome to episode 4 and our fourth lesson in our tutorial sessions on the law of torts. In our previous episode, you remember that we tackled the tort of unlawful arrest. Under that, we identified the 5 requirements you need to prove in order to be able to justify an unlawful arrest. We looked at some Ghanaian cases. We also differentiated arrest by a police from an arrest by a private individual. We again looked at arrest by a warrant and the provisions relating to the tort of arrest under Ghana's constitution. In this particular episode, we will be looking at false imprisonment as an area of law under tort. We are going to identify the elements of the tort of false imprisonment and highlight the major principles you would need to explain these elements. This, we hope, will help you appreciate how they are applied in various ways and in various forms. So let's begin. What is the tort of false imprisonment? False imprisonment is the act of restraining a person against his or her will in a bounded area without any justification and without the consent of such person or without legal authority. See the case of Sarah versus Lapin. Next, to know the difference between false arrest and false imprisonment, kindly look at the cases of Davis versus Clark County and the case of Hera versus Montgomery Ward Company. Now let's look at the elements of this particular tort. What are the essential elements of false imprisonment? There are 3. 1, there should be willful detention or imprisonment. There should be the absence of consent. And there also should be the absence of the authority of law or the absence of legal justification to occasion this particular imprisonment. You can look at the case of It versus Lynn Ma. Now, Blackstone has said there are 2 points about false imprisonment, and these are the detention of the person and the unlawfulness of such detention. Every confinement of the person is an imprisonment, whether it be a common prison or a house or in the stocks or even forcibly detaining someone in a public street. Unlawful or false imprisonment consists in such confinement or detention without sufficient authority. What is the principle in support of the first element, the willful detention? In Warner versus Rutherford, it was held that to constitute an imprisonment, it was not necessary that the person should be locked up within 4 walls, but that if he was restrained in his freedom of action by another, that was an act of imprisonment. In the case of Amin versus Merck Company, it was held that a detention may be accomplished by violence or by threats or by any other means that restrains a person from moving from one place to another. Now, one may now ask, what is the scope of restraint required in order to constitute imprisonment? The restraint in order to amount to imprisonment must be total. In other words, the person must be confined in all directions. If it is only partial, leaving a reasonable means of escape, then no false imprisonment has occurred. You can look at the decision in Coleridge J in the case of Bird versus Jones. In Wright versus Wilson, C.J. Holt stated that an action in false imprisonment is when a man has 2 doors through which he can go out and one is blocked, leaving the other free, though the second one he can go through only as a trespasser, but an escape route which exposes A to danger is unreasonable and amounts to false imprisonment. Again, in Williams versus Harsey, Fologa J. reaffirmed the principle by stating, where there is only one route, obstructing the route will amount to false imprisonment. In all said about using a reasonable means of escape when there is one available, the question that comes next is that, will the person imprisoned be entitled to anything after he uses the available reasonable means to escape? Well, our answer could be seen in the case of Sayers versus Haller. It was held that where a person uses a reasonable means of escape and gets injured in the process, he is entitled to damages. What about when you keep a person at a place for a specific time as indicated by the person? Viscount Haldane in Head versus Weardale Steele answered this question by stating, where a person agrees to be at a certain place for a specific time, keeping the person at that place within that agreed time does not amount to false imprisonment. Again, where a person agrees to be at a certain place for a specific time, keeping the person at that place within that agreed time does not amount to false imprisonment. Also, what about the instance where a person imprisoned at a certain place asks you to provide him or her a favor to escape? Lord Lawburn in Robinson versus Balmain New Ferry Coy has this to say: failure to provide gratuitous exit to a person imprisoned does not constitute false imprisonment against the person who failed to provide the gratuitous exit. Failure to provide gratuitous exit to a person imprisoned does not constitute false imprisonment against the person who failed to provide the gratuitous exit. Also, prominently, we see that hospitals, event centers, among others, sometimes refuse to allow somebody to leave because the person has failed to make full payment or satisfied all his obligations under a contract. Thus, the question to ask is, that does constitute false imprisonment? Lord Abinger answered this question for us in the case of Sandboff versus Aldorf in the following words: where a person contracts to leave a place on some amount of false imprisonment and without any lawful process, detaining someone to enforce a contract is false imprisonment. You may use this case to support the third element as well. Another question is, what is the principle in support of the second element? The element proving without consent. We would address this element by focusing on the presence or absence of awareness of the imprisonment on the part of the person imprisoned. So the question stands: is awareness material? Three cases demonstrate this. In Herring versus Boyle, Justice Boland held that to constitute false imprisonment, the plaintiff must be conscious of the fact of the imprisonment. However, in Mearin versus Graham White Aviation Company, Atkin LG reversed that principle and stated the new principle as follows. He stated, it is perfectly possible for a person to be imprisoned in law without his knowing the fact and appreciating that he is imprisoned, irrespective of the state of affairs of the person imprisoned. Those are cases where it seemed to me that a person might properly complain if he were imprisoned, though the imprisonment began and ceased while he was in the state. Of course, the damages might be diminished and would be affected by the question of whether he was conscious of it or not. Lord Griffiths in Murray v. Ministry of Defence affirmed Atkin LJ's principle in simple words. Consciousness of imprisonment is not an essential element to establish a claim in false imprisonment. Moving on the last element, the element of the absence of lawful authority, in Warner v. Rediford, it was held that the unjustified restraint of the freedom of action of a person by another constitutes false imprisonment. There has to be an intention to do the act. Who will be liable for the tort of false imprisonment in this particular instance? In Onogen v. Laventis, Edumwa Bosman J, as he then was, described the person as follows. An action for false imprisonment will lie against any person who authorizes or directs the unlawful arrest or detention of the plaintiff by a mere ministerial officer of law. He makes that ministerial officer his agent and is responsible for any arrest or detention so procured or authorized, as if it were his act. However, mere information given to such an officer on which he acts at his own discretion is no grounds for liability. You can see also the case of Nkrumah v. Foley, where a person offers mere assistance to the police to do their work. Contrast this case with the decision of Austin v. Dolin, where Willis J. held as follows. Where a person expressly directs the detention of another against the will of the officer of the law, the detention is direct and is the direct act of the first named person. In all, after liability is established for false imprisonment, the person who suffered may recover nominal damages as well as compensate for mental suffering, including fright, shame, and mortification from the indignity and disgrace consequence upon an illegal detention. You can see Barnes versus District on Columbia for more on this particular point. The element to be considered in awarding compensatory damages in a false imprisonment include physical and mental suffering, humiliation, loss of time, interaction of business, reasonable and necessary expenses incurred, and injury to reputation. The case of Jenkins versus Pick and Pay Shoes Incorporated illustrated this particular point. Also, the measure of damages for the false imprisonment is a sum that would fairly and reasonably compensate the injured person for the injuries caused by the wrongful act, including any special pecuniary loss which is a direct result of the false imprisonment. The case of Sindel versus New York City Transit Authority illustrates this point. This is the end of the 4th episode. We hope you learned enough. And we also hope you join us on our next episode where we'll deal with malicious prosecution. As we say in every episode, like, comment, share, and stay tuned for more updates on this particular channel. Thank you and good luck.